petition should therefore continue to be heard and decided by the present bench. Any change in the composition of the bench is neither necessary as a matter of law or of propriety, nor is it advisable at this end stage of the case. Indeed, including the case would serve in the public interest, as much of the time and public money have been expended in hearing the instant petition. There is a dissent, my lord, at page 431. And if your lordship may see the opening paragraph by my lord Mr. Justice Syed Mansoor Ali Shah, I raised the following question during the hearing of this case on 18th August. Whether this bench should continue hearing this case, or should this case be adjourned till the court first decides the constitutionality of the Supreme Court Practice and Procedure Act 2023, or in the alternate, should a full court hear this case pending decision on constitutionality of this court. Then his lordship gives the reasons what transpired that day. Paragraph 5, his lordship refers to my submission. The Learned Counsel for the Federation has argued in favor of adjourning the hearing of the present case till decision on the constitutionality of the Act, or in the alternate, constituting a full court bench to hear it, mostly for the same reasons as recorded in my last order and reiterated above, and no satisfactory answer has been put forth by the Learned Counsel for the petitioner to the proposition recorded therein, that if ultimately the court upholds the constitutional validity of the Act, any decision given in the present case by this bench, which is not constituted as per the procedure prescribed in the Act and of the strength of judges required under the Act, may arguably be quorum non juris and thus a nullity in the eye of law. The order of my learned brothers, I submit, most respectfully does not address this concern either. Even they note in their order that it would clearly be presumptuous of us to assume the outcome of the above issue. The decision of the constitutional validity of the Act is an equally possible decision with that of its constitutional invalidity. It is not a presumption or speculation. No one can be sure of either of the decisions before pronouncement of the same by the bench concerned. Further, it is not the matter of compliance or non-compliance of the interim order passed by the 8-member bench, which is only of temporary nature. The real concern is the effect of the possible final outcome of the constitutional validity of the Act on the present proceedings and any decision given therein. There is a possibility that the instant proceedings and the decision given therein may become quorum non juris and a nullity in the eye of law if the constitutionality of sections 3 and 4 of the Act is upheld by the other bench. So this Damocles sword hanging over these proceedings can easily be removed if either we await the decision of the 8-member bench on the constitutionality of the Act, or make it ineffective by placing the matter before a full court bench. The interim order of the 8-member bench suspending the Act was passed on 13th April 2023, more than 4 months ago, and there is no next date of hearing fixed in the case. This unnecessary delay in adjudicating a matter which directly deals with the core functioning of this court is not understandable, considering that almost 50 hearings have been held in the instant case. It therefore doubly requires that the constitutionality of the Act be decided first as the earliest, so that the court can function in accordance with law rather than under the uncertainty of a stay order. I therefore maintain my earlier view in my note of 22nd June 2023.
What was your ground for constitution of larger bench or for staying the proceedings?
My lord,
your ground, what on which?
My lord, section 3 and 4 of the Practice and Procedure Act.
4 talks about interpretation of constitution, whether any constitutional interpretation was required in this case?
Yes, my lord, because they were asking for the striking down of several procedures, provisions of the NAB Amendment Act. There was on the touchstone of the Constitution. The argument being made was that it violates a number of provisions of the Constitution, the provisions relating to fundamental rights, provision relating to Islamic provisions, provisions relating to power of and authority of Parliament, provisions relating to virtually how a power is to be exercised. All of those were in question.
There's also another ground, speaking for myself,
my lord,
where a larger bench should have heard this case, and that was the question of maintainability. because in high courts certain petitions were pending, challenging the vairis. And the judgment of the majority did refer to the Benazir Bhutto's case, PLD 1988, Supreme Court 416, which is, I believe, an 11-member bench.
My lord.
And that is the law till today.
My lord.
And again, this court is ignoring that law. So either that was binding and had to be followed, so any departure that was required to be made had to be heard by a larger bench.
My lord,
so that is...
May I respectfully am very grateful for that observation. I had spent an entire day arguing Manzoor Ilahi and arguing on the basis of Benazir Bhutto and pointing out that there was a petition pending under Article 199 of the Constitution before the Islamabad High Court, and in view of the pendency of that petition and in view of these two judgments...
You see, regardless of that, Makhdoom Saab, with great respect, the larger bench judgment is binding even on this bench, because that's an 11-member bench.
Yes, my lord.
And Manzoor Ilahi's case has been reaffirmed by them.
Yes,
and that is the law.
Yes,
and that law is again and again ignored.
Yes,
and that was also ignored in the election matter, to which the majority has made a reference.
My lord, yes.
So that could not have been overruled, and till that is not overruled, 184(3) petitions are not maintainable if matters are pending before the high courts.
My lord, even before the Practice and Procedure Act was enacted, that was a submission made by me before the Honorable 3-member bench of this Honorable Court, and that was my next point, which your Lordships has encapsulated far better than I could.
Arguments, we will hear you later. This is your main arguments.
My lord, that's my second argument. After the Practice and Procedure Act, the second argument...
What is the first?
My lord, the first was that in view...
What is the first proposition?
The first proposition is that in view of the provisions of the Practice and Procedure Act 2023, the proceedings before this Honorable Court's 3-member bench had become quorum non judice, and the matter should have been referred to a committee.
No. So are you saying this judgment is a nullity in law?
That's what I am submitting, my lord.
What do you say about when the Practice and Procedure Act was suspended? It was not in field.
My lord, your lordships knows it better than me that an order of stay operates inter partes. It operated between them, and my lord, Mr. Justice Syed Mansoor Ali Shah refers to my submission and encapsulates this very well, that if tomorrow this Practice and Procedure Act will be upheld, the stay order will be vacated, and for that period...
So you were prescient, or was Justice Shah prescient?
My lord, this
both of you.
The members of this honorable bench are always prescient.
Makhdoom Saab, speaking for myself, the petition was not maintainable in the light of the law laid down by the Benazir Bhutto's case.
My lord, and that was my submission even prior to the 2023 Act, because the Act came in between.
चलिए ये एक proposition हो गया, अगला proposition.
Sir, अगला proposition ये है कि on the same issue, a constitution petition under Article 199 of the Constitution, being petition number 2557 of 2022, challenging the vires of the law, was pending before the Islamabad.
So I'm just thinking aloud, don't read too much into my observations. It could be that a petition comes here and someone, just to stop that, files a petition in the High Court. Okay, it could be completely malefides. Okay, how would we know it? We can't know malefides and bona fides, and that will happen. So should that not be a matter of case-to-case basis, just because a petition has been filed? Or, for instance, some things are time-related, like, you know, it's very important, something happens and a party is not interested in adhering to a certain time. Let's take elections, for instance. So they file a petition, one in Balochistan, one in Sindh, and someone files who's actually interested in elections in the Supreme Court. So the Supreme Court should say, hang on, let's debate those. But they will effectively get the relief what they wanted, delay. So should it be binding on us to that extent, or we have to actually consider the merits of each case, whether in this matter we should await the decision of the High Court? No, the heavens won't fall, we can easily await it. In some other matter, no, we must proceed immediately and decide it.
My Lord,
or is there a hard and fast rule we have to follow?
No, my Lord, even in Benazir Bhutto's case...
We want to hear your view.
No, may I just point out what this Honorable Court has observed? In Benazir Bhutto's case, their lordships described the principles in Manzoor Ilahi as the salutary principle, but in the facts and circumstances of the case did not follow that route, did not pursue the route. They created a distinction. So what your lordship is observing, your lordship will look at the facts of the case, but over here it was not a case where to divert the proceedings from this Honorable Court to the Islamabad High Court. This petition was filed. The Islamabad petition had predated this. That petition was filed by the Islamabad High Court Bar Association. It was not filed by any surrogate petitioner, and it was pending the hearing, and that objection was raised at the very first stage before this Honorable Court that the Benazir Bhutto's case applies.
Benazir Bhutto, we're talking about the election matter.
No, my lord,
Which Benazir Bhutto?
My lord, the political party's case, the first case, that is 1988 Supreme Court 416.
Halim Saab wala faisalah.
Yes, my lord.
My lord has rightly pointed out and very eloquently in Benazir Bhutto's case, these concerns have also been addressed.
Yes, my lord.
And addressed at length and very eloquently.
Yes, my lord.
That when a petition under 184(3) will not be taken up.
Yes, my lord. Yes, my lord. And their lordships in that case, as your lordship knows by your lordship's detailed reading of the judgment, have evolved the doctrine of effective pendency. That if what the High Court was doing was virtually not proceeding with the case and virtually frustrating those proceedings, then not proceeding in the Supreme Court would not be countenanced by this Honorable Court. It was submitted that that was not the case over here. To the contrary, after filing the petition in this Honorable Court, adjournments were being obtained from the Islamabad High Court that now that we have gone to the Supreme Court, please don't proceed over here. So it was an altogether different situation, and that is why it was relied upon.
Let me clarify one thing from you. If, there's a big if, capitalized big if, we accept for the sake of argument, don't think we have, this quorum non judice. Are you just relying on that ground, and then the petition in Islamabad High Court gets revived and we just stop?
My lord,
or are you also going on the merits?